Good evening, everyone. I'm delighted to welcome you to our YouTube class on the topic Digital Personal Data Protection Act, relationship between data principals and fiduciaries. In an era dominated by digital advancement and data-driven technologies, safeguarding personal information has become a critical concern. Today, we will delve into the intricate landscape of data protection under the DPDP Act. Our focus will be to illuminate the essential relationship between data principals and fiduciaries and unlocking the key dynamics that define responsible data management. To this end, I am honored to welcome Mr. Gaurav Goswami, a data privacy and IP expert with many years of academic and practical experience in this field. Mr. Goswami is currently working as a data privacy and IP lawyer at his practice, Privy Law, and was previously an assistant professor at UPES Dehradun in Campus Law Center, Delhi University. He is an expert in data privacy and protection laws, having had a dynamic career in this field, and I'm certain that his insights today will be valuable contributions to our legal learnings. It's a pleasure having you here with us, sir, and I look forward to an interesting session. Thank you so much.
Thank you, Kashish, for the warm introduction and for organizing this lecture. So, thank you so much. I think we can begin, right? So, yes.
Yes, sir, I'll just load up the PPT.
Right.
It's on
So,
specific.
yes. So, good evening, everyone present. So, I will be giving a lecture on DPDP Act, that is Digital Personal Data Protection Act, which was recently introduced by the Indian government, right? So, what DPDP Act is you can say it's a development after the GDPR in European Union. We have followed pretty much major part from the GDPR only. So what I will be talking about is a relationship between the data principals and the data fiduciaries, right? So these are the two main stakeholders in the when we talk about data protection. So data principal and the data fiduciaries in India, and we call data subject and data controller in under GDPR, right? So the relationship between these two, as I mentioned, that the whole data protection revolves around these two entities, the data principals and the data fiduciaries. So what I will be discussing today is I will give you a brief introduction to the DPDP Act, right? What it is about, why it has come, then its application, and where it is applicable, territorial, and we will be also looking at the important definitions which are relevant for today's lecture, right? Further, I will discuss with you who are the principal stakeholders when we talk about the liabilities, duties, and rights under the DPDP Act. Further, we look at the obligation put up on the data fiduciary by the DPDP Act. Additionally, they have put up certain obligation, a strict obligation upon the significant data fiduciaries. And in the end, I will talk about the rights and duties of the data principal. So, the whole DPDP Act, if I say that it revolves around these two entities, I would say data principal and the data fiduciary, right? So first looking at that, why, I mean, for everyone it comes to their mind why this act has come, right? So every law, every piece of legislation, every act, it has certain objectives, right? So if you look at the DPDP Act, it's also have certain objectives, and that are, I mean, if I tell you that there is a conflicting interest. At one side there is a private interest, and on the opposite there is a public interest. Now what that is, so at one side there is a general public, those I can say the subjects or the individuals, those who provide their information, the data, right, on the online platforms or in a digital form to the entities, or to the entities or the companies, right? So you are, there is one party that provides the information and the data, and the other one, those who process the this information that has been collected or to be processed, right? So the issue raised when the right to privacy, to data protection came up, the people became realized that I mean their information is being used at other platforms also without their consent. They're not knowledgeable of that, the information about them, the sensitive information regarding their health, their age, and all which they have provided to certain entity, it has been shared among others also, to which they have not given the consent. So it obviously, I mean, it obviously violated their right to privacy, right? So this act has come up to balance the conflict. Now, at one part, the data principals, or you call the data subject, whose data is being collected and processed, that they do not want their data should be shared, right? And if that to be shared, then there should be some mechanism there to protect their data, right? I mean, it should not be freely available everywhere on the internet. And the opposite party, the conflicting, is the data fiduciaries or the data fiduciary that say that wants the data, because as you know, it's a knowledge based economy now. I mean, the top companies or the top contributor to the GDP of the countries is the are the technology run companies, those who are data intensive, right? So this act do, what the GDPR did is they balances the conflict. So what GDPR provides and what DPDP Act provides are the kind of similar, right? So if you look at the DPDP Act provide for what, it recognizes that the rights of individual to protect their personal data, that the government realized that there is a urgent need to protect the personal data of the individuals, and at the same time government has the realization that the with the upcoming technology based economy, knowledge based economy, they require this data, otherwise there will be an impasse, right? So to balance this thing, that the data shall be freely available first thing, then when the data is available, it should be rightly protected. So that's the objective, that's the problem before the government to overcome. So the solution they come up with after a long wait and long discussions and the reports, they come up with this DPDP Act, that is Digital Personal Data Protection Act, right? So moving ahead, so this if you look at this cartoon, it pretty much explains that how this problem arised, right? So you go to the to lifestyle or any showroom to buy something, they will ask you, sir, your name, your date of birth, your mobile number, your email ID, and everything they will ask you, and they will say we will provide you 5% of the discount. So and later on you come to know that you have provided them you only went to buy a shirt there, you went to only buy a pant there, your tailor do not ask you all these details, right? So what they did, they used this data on other platforms also, so without your consent the data was being used. So this cartoon pretty much explains the issues, right? So further we will be looking, I will discuss with the application, so on what kind of data this DPDP Act applies. So it applies to the personal data that is collected in digital form, right? And even if it is not collected in digital form, and subsequently if it is digitized, like someone took your detail on page, then it is being digitized, then yes, DPDP will be applicable, right? So any personal data that has been collected in a digital form or in non-digital but later digitized, the act will be applicable, right? Now this act does not apply on certain areas, like when the individual, the one who has provided his personal data, has used it for is used for the domestic purposes, or he has himself made the data public. And if the under any obligation under the law he has been asked to share his details, personal details, then in all these scenarios the personal data that has been shared by the individual, it will not be protected, or it will not be required under the act for the penalties or the or any sanction, right? So if you talk about the territorial application of this act is applicable to the India, the citizen individual. It does not talk about the citizen. So if any individual who is living in India and his data is being processed by an entity in India or outside India, if they're processing, this act will be applicable. The data fiduciary will be held liable for if they are not observing the requirements under the act, right? So this is about the application where does this DPDP Act apply. So I told you that upon the digital data it is applicable, where it does not apply, and what are the territorial application of this act, right? Moving further, now we have to look at, before moving further, I mean, before we come to the relationship between the data fiduciary and data principal, we should know what these terms mean. I mean, we everyone talks about the word data. I mean, what it actually means when we talk about legally what the act provides, it says it means So the definition is an exclusive one when you talk about start. So it has given a definition. It says it means a representation of information, facts, concepts, opinions, or instruction in a manner suitable for communication, interpretation, or processing by human being or automated being. So this is the exclusive definition. Nothing can be added up, nothing can be taken out. So this is the definition. It includes the data means any information, any fact, any concept, any opinion about the individual. So all these things are inclusive in the definition of data. So when you talk about who is a data fiduciary, data principal, data processor, now these are the main entities about around which the whole act revolves, right? So who is a data fiduciary? It could be any person. When you look at the definition of person, it's a long list that has been provided. It could be a company, it could be LLP, it could be an entity, it could be an individual. So the definition of per person which has been provided under DPDP Act is quite a large one, right? So many can many entities fall within the definition of this person. So a data fiduciary is a person who alone or in conjunction with other person determine the purpose and mean of the processing. So data fiduciary is the one who collects the data, and he determines the purpose, right? How the data to be processed, and what will be the means of processing, right? So how the data will be collected, why shall be collected, and in what manner it will be collected. So collection, I am giving you an example of collection, as collection fall within the definition of processing, what data processing is. Now further moving, who is a data principal? A data principal include three people. They have said, I would say, where they have included in the definition of individual. Data principal means an individual to whom that personal data relates. So the person uh, whose data is being collected or being processed, the person that will be taken as a data principal. It includes even a child, and a child includes the parents or lawful guardian of such child, right? Apart from that, if a person who is an individual within the definition of data principal, if he is suffering from any disability, it will include his lawful guardian and those who are acting on his behalf. And one good thing to note is this: on this whole act, the usage of word his is not there. Only her is being used in the whole act, right? So you will notice that this act is mentioning her. I mean, the whole from page one to the end part. So who is a data processor? Moving further means any person who processes. So the data fiduciary only does what it determines the purpose and means of the processing. The actual processing, the one who does, is the data processor. So the data processor work under the guidance and the direct control of the data fiduciary. So these are the certain definitions which I wanted you to know, and these are also the key stakeholders when we talk about the DPDP Act's compliance. Moving further, what personal data means. Now we have talked about data, what data means. Now what is a personal data? What comes within the ambit of personal data? So it means any data about an individual who is identifiable by or in relation to such data. So any data from which an individual can be identified. If I provide my Aadhaar card, right, it has all the details by which I can be identified. Or if I only give my name or certain area where I live, but if through this much of data, if I can be identified through the relationship of the data, then that data will come within the ambit of the personal data, right? So looking at further, what personal data breach means, right? So the breach means any unauthorized processing of personal data. The first part says any unauthorized processing of personal data. It could be intentional, right? When an individual is knowingly using the processing the data unauthorizedly, kind of an infringement. But this act is much more stringent, as it also take in consideration the accidental disclosure, acquisition, sharing, use, alteration, destruction, or loss of access to personal data. That will also come under the personal data breach. What I mean is, not only when you have knowingly processed the data which you know is unauthorized, and you have done it, not only that, that will make you liable for the penalties, but even if you have accidentally disclosed the data, if and if there is been a loss of certain access to the personal data, then also you will be held liable for the personal data breach. Now, what is processing? Sorry, what is processing? So in relation to personal data, the data through which an individual can be identified. So it means a wholly or partly automated operation or set of operation performed on digital personal data. So operations which are performed on the digital personal data, it could be wholly or it partly automated. So it is important to note, it talks about the automated operations or set of operations. So what these operation, this initial part, it talks, it gives that what processing mean wholly or partly automated operations. Now these operation may include, these may include the collection, recording, organization, structuring, storage, adaptation, alignment. If you are doing any of these activity with the data which has been collected, it will be held, it will be taken as a processing. Now, so I will move further. I mean, this is the processing. Even the eraser, making available to other, destruction, these all come within the definition of processing. So you take a note that the definition of processing is quite enlarged one. Now, moving further. So these are the principal stakeholders when we talk about the DPDP Act. So data fiduciary, you know about who is a data fiduciary, who is a data principal, who is a data processor. Now, two things: the data protection officer. Now, this act requires employing a data protection officer, not by all the data fiduciaries, but by the significant data fiduciary. So, under this DPDP Act, the government has come up with the concept of the significant data fiduciary. Now, who is a significant data fiduciary? They have not given a definition, but say it will be decided by the government. Government will come up with a list. I mean, maybe so. Okay, that these people these entities will fall within the significant data fiduciary. How they will be deciding? They have mentioned they will check whether the volume and the sensitivity of the personal data, the data fiduciaries which are collecting the data, which are processing the data in large volumes, and that is a sensitive data, and about the risk that processing imposes on the rights of the data principal. All these will be taken care when demarcating between the data fiduciary and the significant data fiduciary, right? So these are the principal stakeholders. Now, the whole act provides for, if you look at the larger chapters of this act, it majorly provide the obligations on the data fiduciary. Or data fiduciary is the one who decides the processing of the data processing of the personal data that has been collected, right? So now data fiduciary, he is allowed that you can process the data, but subject to what? That you must have taken the consent of the data principal, the one whose data it is, right? You must have to take the consent. Without consent you cannot. Or so for certain legitimate uses. Now these are the only two manner in which you can start, the data fiduciary can start the process, only these things, under these circumstances, right? And this you have to follow the provisions of the act as well as, and it should be, the data processing should be for the lawful purposes only, right? And the act defines what a lawful purpose mean. It says any purpose which is not expressly forbidden by law, right? So moving further. So I mentioned that the whole act is about the obligation on the data fiduciary. So I'll move further. So there are certain requirements from the data fiduciary, that they have to take the consent before collecting the information, before even starting the processing. So they have to be, even before the requirement under the act start, before even the processing start, the moment you are asking the data principal to provide you the consent, before the consent you have to provide them with certain notice, and the notice should explain the data principal, the one who is providing you the detail, about the purpose, that why you are collecting this information of mine, right? That how you will, how the data principal, the one who is providing the detail, he can exercise his rights, right? And apart from that, how I can make a complaint about it if it all anyhow infringes my rights. So you have to give the notice to the to the data principal even before collecting the data, their data, right? So now the consent which we are talking about, it shall be free. It shall be free consent. It should be specific one. It should be an informed one. It should be unconditional and unambiguous. And there should be an affirmative action, clear affirmative action on the part of the data principal who is providing you the consent, right? What I mean by clear affirmative action is that you cannot pre-fill the documents, and you cannot pre-check the consent, right? You do not ask them only to click one button and go after. They should be it should be There should be some act on part of the data principal which shows that yes, he agrees, he provides his free, specific, informed, unconditional, unambiguous consent to you to process his or her data, right? And this act should signify that agreement of the processing of her personal data for the specified purpose, and be limited, and the data fiduciary has been asked to be limited in their processing, right? And only for a specified purposes. So this is one of the obligation which has been put up upon the data fiduciaries, right? Moving further, now, apart from that, the giving of notice and the requirement for collecting the consent, there is a long. I mean, I would say whole act is filled with the obligations on the data fiduciaries. So, moving further, if you look at where consent given by the data principal is the basis of processing, when the only affirmative action, I mean only thing on the basis of which you are moving with the data processing is the consent only, then data principal shall have the right to withdraw her consent at any time. The data principal can anytime withdraw their consent. Now, and now at times we saw that entering into a contract is easy, but when you want to your way out, the things are made quite complicated, that before leaving you have to do this, you have to do that, you have to provide that. But this act itself, it asks that the manner you are asking for the consent, the way it should be easily accessible. The similar way, when the person wants to withdraw their consent, the process should be very much easy. It should be easy in comparison to the when you were asking them to give their information, right? So this is one. They cannot harass the data principal that your services will not be, you will not be able to do this and all. So they have to make the comparably easy. They have to provide the comparable ease to the when the individual is withdrawing their consent. So apart from that, the data fiduciary shall, within a reasonable time, seize and cause a data processor to cease the processing. The moment the data principal withdraws their consent, the data principal has to, within reasonable times, have to seize and cause its data processor to cease the processing. You have to stop the processing. Now, moving further, where personal data processed by the data fiduciary is likely to be used to make a decision, right, that affect the data principal, then you have to make sure, I mean the data fiduciary, they have to make sure that the data which they are using is complete, it is an accurate one and consistent one. Why it is? Because there has been cases where the use of the technology is done when processing the data, and the outcomes are biased. So removing the biasness and taking care of the human rights also, this has been required when you are making any decision on the basis of the data processing. Then you have to make sure that the data is complete, accurate, and the consistent one. Apart from that, data fiduciary not only has to follow all these principles, apart from that, they have to implement appropriate technical and organizational measures. So they have to come up with a efficient technical team which provide for the data protection. They should be using all kinds of softwares which take care of the data protection. Apart from that, organizational measure, they should come up with a policy at their offices. They should They should sensitize their staff about the data, the importance of data privacy and the data protection. So these can be taken up by the data fiduciaries as a practice. Apart from that, they should always take reasonable security, and the data fiduciary shall give the board and each effective in case of a sorry and where there is a case of a personal data breach, the data fiduciary shall give the board and each effective data principal information whenever there is an incident of a data breach. Then it's a duty of the data fiduciary that he has to inform the board about the breach and the individual, the that is the data principal, in case of the data breach. If they fail, so there are harsh penalties upon them. So I'll move further. So, apart from that, the data fiduciary are required to erase the personal data after the withdrawing of the consent by the data principal. That is one. They have to erase the data. They have to publish on their website or in the notice the person to whom they should approach when there is a case of data breach, or in case when they want any assistance or they want to exercise their any right which are provided under the act. Then the data fiduciary, they should provide the information of the data protection officer to the data principal, right? Now, apart from that, this they have to establish an effective mechanism to redress the grievance of the data principal. I would like to make one add one thing, that not only you have to comply with this, the data fiduciary not only have to comply with all these things, they have to show, whenever asked, they have to show that they are compliant. So it is not only on books that we are data, they have to provide proof that we are data compliance compliant, but in practice they have to show that how the effective step, what are the effective steps they have taken up to ensure the data protection of the individuals, right? So now, apart from that, when we read about the definition of data principles, it included the child and the disabled. So when you talk about the processing of the personal data of a child, there are certain requirements which are to be fulfilled by the data fiduciary. These are that they shall not undertake any processing that is likely, not to that would cause, that is likely, even there is a likelihood of cause that there will be any detrimental effect on the well-being of a child. Then the data fiduciary shall refrain from doing such processing of a child. Apart from that, they shall not undertake tracking or behavioral monitoring of a child or target advertising on the children. So the specific provision has been envisaged in the act itself for the protection of these childs, right? So apart now I've talked about the duties and the principles and the practices that should be adopted by the data fiduciaries. There's a additional data fiduciary in the act itself, that is a significant data fiduciary. So apart from following what the duties have been put up upon the data fiduciary, a significant data fiduciary has to take additional steps, which the data I will say normal or the other data fiduciary have to take. Now the requirement is that they have to appoint a data protection officer. The significant data fiduciary, they have to appoint a data protection officer. This is not required on or for the data fiduciaries which are mentioned earlier. Only a significant data fiduciary has to appoint a DPO. It has been mandated by the act itself. So now what will be the role of the DPO? So the DPO will be the one who represent the significant data fiduciary under the provisions of this act. He will be taking care of the all the policies and the exercises that has to be taken care to bring in compliance with this act. And there are certain requirements also, that the DPO shall be based in India. He should be based in India. He can be an individual. He should be responsible to the board of directors or similar governing body. So in the entity of data fiduciary, significant data fiduciary, this data protection shall have the access to the board of directors or similar governing body. So it's an important post that has been created under this act. Apart from that, be the he should be the be she should be the point of contract, oh sorry, contact for the grievance redressal mechanism under the provisions of this act. So whenever there is a breach or a request by a data subject for the access, for accessing their rights under the act, then this data protection officer is the one who shall be contacted. So he should be always available. So the one requirement is for the significant data fiduciaries is they shall appoint a data protection officer. Apart from that, the significant data fiduciary, they shall appoint an independent data auditor. They have to appoint an independent data auditor to carry data audits. It will include that the data auditor shall evaluate the compliance of the SDF, I will say, significant data fiduciary, that in audit to be conducted a frequent I mean a periodical uh, data audit to be conducted by a data auditor, taking care of whether all the policies, all the practices, or the implementation, even on a IT or in legal departments, are in consonance with the spirit of this act, or in accordance with the provisions of this act, right? So there should be an appointment of the DPO. There should be an appointment of data auditor by the significant data fiduciary, and these are the mandatory, these are the word used is shall, so these are the mandatory exercise that has to be taken care by a significant data fiduciary, right? Now, apart from that appointments, there is certain other requirement which have to be fulfilled by the SDF. That is, they have to conduct data protection impact assessment, periodic, right? So they have to conduct periodic data protection impact assessment. We know what data protection impact assessment like. It can be conducted at any time. I mean, it is much relevant when you are looking for privacy by design, right? So before starting any project which you think is in which you will be processing the sensitive information, right? Then it is must that the data fiduciaries, before starting or collecting the data, they should come up with a data protection impact assessment. The impact assessment is nothing but you have to you have to keep a check. It allows you to keep a check on the upcoming threats which might occur during the processing. So impact assessment is a necessary exercise which should be taken care by the which should be taken by the significant data fiduciaries, right? So apart from that, there should be a periodic audit by the SDF. Apart from that, they should other measure consistent. They have to take care of all the duties which are imposed on the data fiduciary. Apart from that, these three requirements are put up especially upon them, that you have to appoint a data protection officer, you have to you have to appoint a data auditor, right? And apart from that, you have to undertake the periodic data protection impact assessment and the periodic audit for the same, right? Moving further, now, what we have done is we have talked about the duties of the data fiduciary and the significant data fiduciaries. Now, when we look, now we can start with the rights of data principal. This act recognizes the rights of the data principals. So there are certain rights which have legal rights which have been granted to the data principals under this act, which can be exercised by the data subject. So the first right which I will be talking about is the data principal has a right to obtain his data information from the data fiduciary to whom she has given his or her consent, right? Including a summary. You can ask the data principal can ask the data fiduciary to provide a summary of the personal data which is being processed by such data fiduciary or by the processor they have engaged, right? So they can ask for a summary of the personal data which is being processed by the data fiduciary, right? Apart from that, they can ask for the identities of all the data fiduciaries and data processors with whom the personal data has been shared. by such data fiduciary, along with the description of the personal data so shared. Not only the identity of the data fiduciary, data processor, who are the ones engaged with, who are processing their data. Apart from that, the description. I mean, I mean, how much of my information, personal information, has been shared or been processed by such data fiduciary or data processor. Apart from that, the data principal have been given the right that they can ask for any other information related to their personal data which has been processed, and as may be prescribed by the upcoming rules for this act to supplement the act. So this is the first right related to the data principles, that is right to have a right to obtain the information, right? Now, apart from that, the data principles, they have other right, that is the right to correction, completion, and updating and eraser. So this is not one right. I would say right to correction, right to completion, updation, and eraser of her data, personal data, for the processing for which she has previously given her consent. So a data principal can ask at any point of time, they can ask the data processor to correct their data. They can ask to complete, if it is in any manner it is incomplete, they can ask the data processor to complete it, update it, and even the eraser. You can ask for the eraser of your personal data for which you have previously given your consent, including the consent as preferred in clause A of section 7 in the act, right? So you can ask for the corrections, completion, updation, and eraser if you are a data principal. Now, the data fiduciary, when he receives a request from the data principal that they want to correct or complete their data or update their data or erase their data, they have to they have to correct the inaccurate and misleading personal data. Now, if you look at this, I mean, this is a section that provides for the right to correction. The section in its primary section part, it provides for the right. Then further, it provides again a duty upon a data fiduciary that they have to correct it, right? They are duty bound to correct the inaccurate data or misleading personal data. If you see, it has been repetitive in as it was earlier mentioned that in earlier section also, that data fiduciary, they have to undertake these things, these exercises, that they should keep the data accurate, updated, right? And when this has been again reiterated in this section, that they have to, when they receive a request, they have to correct the inaccurate and misleading personal data. They have to complete the incomplete personal data, and they have to update the personal data of the data principal, right? Now, a data principal shall make a request to the data fiduciary for eraser. Upon the receipt of the such request, the data fiduciary shall erase the personal data unless retention of the same is necessary for certain periods. So there are certain purposes which has been provided in the act. If it has been required because of some legal sanction or some certain specified purpose, then they can retain this data, right? This is the second right which I say, right, from the right to obtain to right to correction, completion, updating, and eraser. Now, moving further. Now, next, the next right is the data principal shall have the right to have readily and available means of grievance redressal. Now, whenever there is a data breach or any incident related to, so then the principal has the right to have the readily available means of grievance redressal. Not only the right to have a grievance redressal, it should be readily available. So I think the government will come up certain timeline, certain time limit that the data fiduciary has to comply with, or the consent manager had to to reply or provide the the redressal to the grievance raised by the data principal. So it will be a timeline based, like we see in GDPR. 72 hours have been provided to convey this to convey any data breach incident to the authorities. So similar way, I think the in India they will come up with certain time limit for the exercise of this right. Apart from that, so the same thing has been mentioned in my next para. So the data principal shall exhaust the opportunity before moving to the board it has been mandated that the data principal shall exhaust the opportunity of redressing her grievance under this section before approaching the board. So data principal's right has been curtailed to move directly to the board. They have to first make a representation or make a request for the grievance redressal before the DPO or the data or the data fiduciary before moving to the board, which is to be constituted under this act, right? So you cannot move directly to the board. You have to firstly raise your grievance with the data fiduciary and the officials there. Apart from that, the this interesting right has been granted to the data principal, that is the right to nominate. So a data principal can nominate other individual if in case of a death of the data principal or in incapacity of the data principal or disabilities, the right can be nominated. So it means it can be the right is any alienable, right? It can be assigned to any other individual. So, the word expression incapacity is also been, given a definition under this act. That means incapacity means inability to exercise the right of data principal under the provision of this act, or the rules made thereunder due to unsoundness of mind or infirmity of the body. So, for these two reasons, if you are of unsound mind or infirmity has occurred to the data principal, then it will be taken as an incapacity, and the data principal will have the right to nominate individual who will be on his behalf, can access his right to eraser, his right to correct the data, his right to ask for the complete information and all. So this right to nominate will be very useful in certain cases. Now, this act not only puts is I told you earlier that this right is a balancing act. It takes care of the balancing of interest between the data fiduciaries and data principals. So if you have seen that the whole act has put up a number of duties upon the data fiduciaries, and they are all mandatory in nature. So the act has not left the data principals only with the rights. So they certain duties have been put up on the data principals also. Now, what are these duties? Now, the data principle, the word used is shall. So these are the mandatories to be complied with. So the first duty to a data principal shall perform is he has to comply with the provisions of all applicable law for timing in force while exercising rights under the provisions of this act. So they have to, before exercising the rights under this act, they have to comply with them also, right? Apart from that, to ensure not to impersonate another person while providing her personal data for a specified purpose, because providing impersonating or providing the wrong document, it will create additional duty on the data fiduciary. Apart from that, to ensure not to suppress any material information while providing her personal data for any document, unique identifier, proof of identity or proof of address issued by state or any of its instrumentalities. So you shall not suppress any material information. You shall not impersonate, right? You have to comply with the requirements under this act. So these are the duties they have to fulfill. Apart from that, they have to ensure that not to register false or frivolous grievance or complaint with the data fiduciary or the board. This is very important because already the data fiduciary is burdened with a long list of mandatory duties. So filing or registering a false or frivolous grievance or a complaint with the data fiduciary, it will be an additional or unnecessary, uncalled exercise for the data fiduciaries, right? Apart from that, there is one more duty, that is to furnish only such information as is verifiable, authentic. It is a duty that has been put up upon the data principal, that you do not have only the right to get your data or information corrected. You have to provide your correct data, right? You should not impersonate. You should not suppress. You should only provide the information that is authentic and that could be verified, right? So these are the things. These are the duties which have been put up upon the data principal. These are the duties. Now, when we talk about we have talked about the duties of the data fiduciary and the data principal and the rights of the data subject or the data principal under the DPDP Act. There are penalties which have been envisaged in the act that are for the non-compliance of the act. So these are huge in amount, right? If you look at breach in observing the obligation of data fiduciary to take responsible security safeguard to prevent personal data breach, the penalty can extend to 250 crore rupees. It is not a small amount, right? So if a data fiduciary is not fulfilling their obligation to take the reasonable security safeguard, they for preventing the personal data breach, they can be penalized. So this 250 up to, which may extend to 250 crore rupees, right? So apart from that, breach in observing the obligation, give to the board affected data principal notice of a person. In these cases also, it can extend up to the 250 crore. And apart from that, breach in observance of additional obligation in relation to children under section 9. So the requirement for the that you cannot uh, undertake any any data processing which might be detrimental to the interest of the children. You cannot in those cases, if you are not fulfilling the obligation specifically related to the children, then again the penalties are up to 200 crore rupees, right? So apart from that, in case of breach observance of additional obligation of significant fiduciary under section 10, it will extend to 150 crore. So if you look at it, I mean, if you there are two duties which the significant data fiduciary have to look at. The one which are provided earlier, which are applicable on the data fiduciary, they have to observe that if they are not fulfilling that 250 crore, I believe so. And then if you're not observing your additional obligation which have been put up upon you for child for processing the data of a child, or the obligation which I specifically mentioned under section 10, then the penalty can be extended up to 150 crore rupees, right? Now, in breach of the duties under section 10 15, that is the duties upon the data subjects, then the penalty is also imposed not only on the data fiduciary. The penalty is imposed upon the data subjects. This section provides for, if the data subject is in breach in observance of the duties which we have just seen, then they can be asked to furnish the penalty of 10,000, which may extend to 10,000. Apart from that, breach of any other provision of this act and the rules made thereunder may extend to 50 crore rupees. The rules will be coming, I believe, in January 2024, as the minister has mentioned. So this can extend to 50 crore rupees if you are not following the rules or the other provisions of this act. So we have discussed the relationship of the most important, the principal stakeholders under the DPDP Act. So this is about the relationship between data principals and fiduciaries under the DPDP Act. Thank you, Kashish.
Thank you so much, sir. That was an extremely insightful session. So, if you don't mind, can we open the floor for
Yes,
questions now?
please. Yes, yes, yes.
Uh, Thank you. So, if anybody has any questions, you can put them in the comments. If you have any questions, you can just put them in the comments section of YouTube. So, can we just wait like a minute or something? Just
Yes, 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 please.
thank you. So I don't think there are any questions for now. So
Fine.
uh,
So
maybe we can end this. But before we do, I would just like to thank you for taking your time out and contributing to this project. It
thank
means a
you.
lot to us here
Thank you
in
so much,
closing.
Kashish,
Thank
for
you so much.
inviting me to deliver this lecture. Thank you. Thank you, Kashish.
Thanks. I'll just end this.